Kutcher.
Honourable Senators, I rise today in this chamber situated on unceded Anishinaabe-Algonquin territory as a representative of the province of Nova Scotia within the lands of Mi'kmaq to speak to second reading of Bill S-251, an act to repeal Section 43 of the Criminal Code, Truth and Reconciliation Commission of Canada's call to action number 6. I begin by stating this act, addressing the TRC call to action number 6, is only a small but very necessary step on the path of reconciliation, or as our colleague Senator Christmas has more eloquently put it, reconciliation. I also do not view this repeal as a cure-all for ending all violence against children. I strongly wish that such a cure was possible. That said, repeal of Section 43, which currently provides protection for persons who use corporal punishment as a parenting tool, will be one step on this important journey here at home. I think every member of this chamber wishes that all violence against children would stop. We can do a small part in achieving that goal by supporting the rapid passage of Bill S-251 through this chamber. Senators, physical punishment is defined as, quote, the application of force to induce pain or discomfort for the purpose of correcting or modifying behavior, end quote. And as you will hear from me today, physical punishment is neither necessary nor helpful in guiding and disciplining young people. Indeed, the overwhelming scientific evidence supports the TRC call to action number 6. So let us move forward to make that recommendation a reality. Journalist Carl de Gouze recently penned a piece for the Winnipeg Free Press on the issues around what some have called corrective violence or corrective punishment in parenting. He reminds us how difficult parenting is, and I can speak from personal experience that he is absolutely correct. And that those who spank or otherwise hit their children are not evil or acting out of cruelty. They may have learned this parenting technique through their own experiences or seen it practiced within their own communities. What I will lay out today is that there are much better ways to provide guidance and discipline to children, ways that promote good health and mental health without putting children at risk for poor outcomes. These corrections can be firm and comprehensive. But these techniques do not depend on violence or other types of physical punishment. We also now know that spanking and other types of violence against children often achieve the opposite of what a parent is trying to achieve. And we now know that such use of so-called corrective violence or corrective punishment actually causes harm. Through repeal of this section of the Criminal Code that provides protection for those who use violence as a parenting tool, and by the pan-Canadian promotion of evidence-based parenting supports, we can both protect children from violence and assist all Canadian parents in learning and applying effective and much less damaging child-rearing practices. I also believe that the repeal of Section 43 is a necessary step in our continued evolution towards the type of society we strive to be, one that provides safe and secure environments for the next generations to grow and to thrive. A society that is working on acknowledging and righting historical wrongs. A society that puts the welfare of its children as a top priority. As a society that stands up for those who are not able to yet stand on their own. A society that has evolved its parenting practices from corporal punishments to guidance and positive discipline. Achieving passage of this bill is to uphold the commitments our country has made to abide by the Convention on the Rights of the Child, which Canada ratified in 1991, and to see all 94 of the Truth and Reconciliation Commission's call to action addressed. It also responds to the numerous reports calling for this repeal over the past several decades, including the 2007 report from the Senate Standing Committee on Human Rights, which called for this repeal by 2009. Honorable colleagues, we're 13 years past that date. As a reminder, Section 43 states, quote, "Every parent, school teacher, and person standing in the place of a parent is justified in using force by way of correction of a pupil or child, as the care may be, who is under his care, if the force does not exceed what is reasonable under the circumstances." This clause was the subject of a charter challenge in 2004. At that time, the Supreme Court ruling, which was a split decision, 6-3, and which was accompanied by much public confusion about what was meant by, quote, "not exceed what is reasonable under the circumstances," end quote, included a set of guidelines which were to be followed with regards to hitting children. These included noting that teachers may reasonably apply force to remove a child from a classroom, imposing an age range of 2 to 12 years in which hitting was allowed, and disallowing hitting a child with a cognitive disability, hitting with an implement, hitting a child on their head, or hitting while angry. Of interest, the court did not make any unique mention of those human services providers who must deal day in and day out with young people who demonstrate some of the most challenging disruptive behaviors. Providers such as youth care workers, child care workers, corrections officers, police officers, child psychiatrists and psychologists, and many others. These persons do not seem to be able to access the protections offered by Section 43. As one legal expert told me in discussing this ruling, quote, "Happy second birthday, now we can hit you," end quote. Another commentator said, quote, "It's okay to hit a child as long as the violence is premeditated and nothing larger than a fist is used," end quote. Also, Section 43 provides little, if any, additional protection that alternatives already existing under the law can provide, such as those used in defense when charged with assault. Section 43 is an anachronism, an historical holdover from laws written in 1892 that permitted corporal punishment of employees, wives, and children. Today, we've moved well beyond that. Employers are not legally protected from assaulting their employees. Husbands are not legally protected from assaulting their wives. However, it is still permissible in our criminal code to assault children. Colleagues, as many of us know, this is not the first time a bill addressing this issue has been tabled in this chamber. The last time we saw a similar bill was in 2017. At that time, the bill passed second reading and was waiting for committee study when Parliament was prorogued. You will remember that the last senator to champion the repeal of Section 43 was the Honourable Murray Sinclair, who had been chair of the Truth and Reconciliation Commission. He had taken this on from Senator Hervieux Payette, who had introduced this bill 8 times. I'm privileged to be able to continue this work. In further context, various versions of Bill S-251 have been introduced in the House and in the Senate since 1989. Actually, this will be the 18th time this bill has been brought forward, and I am hopeful that we can now finally see it through. Auspiciously, the number 18 is considered to be lucky in the Jewish tradition. It is synonymous with the word chai, meaning life. I feel that this is a fitting omen. In this chamber, we can provide a better chai for our children by repealing Section 43 on this, the 18th attempt. As many of you know, thoughtful speeches have been delivered in this chamber around repeal of Section 43. But it has been 5 years now since our last debates. Canadian society has changed substantially since 2017. I would ask you to consider how much more we as a society know about the legacy of residential schools. How much more we as a society now know about the negative impact that hitting children has on their development and their subsequent health, including their mental health. How much more we as a society know that parenting techniques that include corporal punishment are no longer popularly supported even by some organizations that in previous decades had condoned or even promoted such approaches. Simply put, in a modern and equitable Canada, there should be no special legal protection for hitting children. There already exist legal remedies against assault. Why should those legal remedies not also apply to children? Why should children have less protection from violence than any other group of Canadians? Many Canadians are asking these questions and have taken up the cause of repealing Section 43. Civil society groups such as UNICEF Canada, Correen's Quest, Canadian Council of Child and Youth Advocates, and over 650 organizations and prominent Canadians that currently endorse the Joint Statement on Physical Punishment of Children and Youth have been imploring the federal government to repeal Section 43. Recently, 9 national child service organizations, including the First Nations Child and Family Caring Society of Canada and the Child Welfare League of Canada, put forward a comprehensive rationale for this repeal. It can be found on the Children's Hospital of Eastern Ontario, CHEO, website. It lays out the issues around children's rights, protection against assault, the evidence for long-lasting personal and societal harms of violence against children, changing Canadians' attitudes towards hitting children, international developments, and legal contexts. I will touch on these issues that have taken place since our last debates 5 years ago. First off, I will talk about the right of children not to be hit, or put into more poignant language, the right for children not to be assaulted. Let us remember that the definition of assault in Canada is, as Section 265.1 of the Criminal Code notes, an assault occurs when a person directly or indirectly applies force intentionally to another person without their consent. When we say physical punishment or corrective discipline, we might be using a sanitized code phrase for assault. Internationally, Canada is falling behind on protecting the rights of children and commitments to reducing violence against children. In 1979, Sweden led the way in outlawing corrective violence against children in any setting. Since then, 62 other countries have enacted laws prohibiting physical punishment of children in all settings. 11 of those countries have moved to do so since this chamber last debated a bill to repeal Section 43. This includes Nepal, France, South Africa, Japan, the Republic of Korea, and Colombia. We were privileged to host Senator Gillian Van Turnout from the Republic of Ireland in the chamber today. She played an important role in having Ireland become one of the countries to prohibit physical punishment of children. That occurred in 2015. We should be embarrassed by how our country is not keeping up its international commitments to end violence against children. Canada has signed and ratified the UN Convention on the Rights of the Child. Section 1 of Article 19 states, quote, "States parties shall take all appropriate legislative, administrative, social, and educational measures to protect the child from all forms of physical or mental violence, injury or abuse, neglect or negligent treatment, maltreatment or exploitation, including sexual abuse, while in the care of parents, legal guardians, or any other person who has the care of the child," end of quote. Since ratifying the CRC in 1991, Canada's progress has been frequently reviewed by the UN Committee on the Rights of the Child, most recently this year for the combined 5th and 6th report, and each review has noted failings in Canada's action on children's rights, and reports have repeatedly called for the repeal of Section 43. Further, in 2015, Canada committed to supporting the UN 2030 Agenda for Sustainable Development. And that document, Target 16.2, calls for an end to all forms of violence against children. In 2018, Canada signed on as a pathfinding country under the Global Partnership to End Violence Against Children. Canada is signing on to international agreements to prevent violence against children and saying the right things, but where's the action? The purpose of the pathfinding countries is to be leaders in prevention of violence against children. How can Canada be among this group if we still permit our children to be hit? What will it take for us to repeal Section 43 which the TRC report describes as, quote, a relic of a discredited past, end of quote, that, quote, has no place in Canadian schools or homes, end of quote. Call to action number 6 simply states, quote, we call upon the Government of Canada to repeal Section 43 of the Criminal Code of Canada, end quote. This call to action is placed in the education section of the report, which demonstrates the significant, long-lasting impacts on Indigenous people that occurred in educational institutions. The shameful legacy of residential schools has had substantive negative impacts on Indigenous communities and families for decades. Many parliamentarians from all sides have stood in this place and in the other place, condemning what happened in residential schools and apologized. Many have pledged their support to seeing all 94 calls to action moved forward. Prime Minister Harper rose in the House of Commons on June 11, 2008, to deliver an apology on behalf of Canada for its role in the establishment of residential schools. He remarked on how new legal remedies would be applied to address the impact of these schools, and how such remedies would form part of a, quote, new relationship, end quote, between Indigenous peoples and other Canadians. Upon receiving the final report of the Truth and Reconciliation Commission in 2015, Prime Minister Trudeau's statement referenced the previous government apology and included these words, quote, we will, in partnership with Indigenous communities, the provinces, territories, and other vital partners, fully implement the calls to action of the Truth and Reconciliation Commission, end quote. Other federal leaders, such as Tom Mulcair, Elizabeth May, Yves-François Blanchet, and Jagmeet Singh, have addressed the importance of the calls to action and the necessity of their implementation. Former Conservative leader Aaron O'Toole called for a plan to tackle all calls to action and said, quote, we're going to make progress on the TRC calls to action because they're very important and they should be beyond politics, end quote. Some have called for action beyond apology. As former Member of Parliament Romeo Saganash said, quote, an apology once made is only as good as the actions that come after it, end quote. Let's take these words to heart, honourable senators. We can act to repeal Section 43. This inglorious legacy itself merits this chamber moving forward to the repeal. Responding to this TRC call to action is, to my mind, enough reason for parliamentarians to move this bill expeditiously. There is, however, additional considerations for the rationale of appeal, and these considerations strongly support the TRC call. Senators, there is substantial evidence demonstrating the enduring negative impact of physical punishment of children. Hundreds of research studies from many different countries conducted across decades have consistently demonstrated that physical punishment places children's physical and mental health at risk and that it worsens behavior over time. Furthermore, and very importantly, there is simply no substantial body of research evidence that demonstrates that corporal punishment of any kind is actually helpful for children, or that it has a positive effect on child health and mental health outcomes. This evidence informs shifts in thinking and practice about physical punishment, similar to social shifts in seatbelt use and the impact of exposure to secondhand smoke, based on evidence of harm. These realizations hit a tipping point, and we acted. I believe we are now at another tipping point for physical punishment of children, and we have the power to act. Indeed, a recent study has shown the negative impact of corporal punishment on child brain development. Children who are hit become more highly reactive to perceived threat, which is part of why physical punishment is consistently linked to increased child aggression. Being hit translates into hitting others. And good evidence compiled since 2015 now clearly demonstrates that what was once called mild corrective force also has substantial negative impacts on children. In 2016, researchers Gershoff and Grohl and Kaler conducted a comprehensive meta-analysis of 75 scientific studies related to non-injurious spanking that was intended to correct a child's misbehavior. This was the kind of punishment that is consistent with the guidelines of the 2004 Supreme Court ruling. Such force does not leave a mark, is not applied to the head or to the area around the head, and is not applied with an instrument. This is the type of assault that colloquially is called spanking. They showed that across the board, spanking children is associated with more aggression, more mental health problems, greater negative relationships with parents, and lower cognitive ability. In their concluding statement, they said, quote, "There is no evidence that spanking does any good for children, and all evidence points to the risk of it doing harm," end quote. More recently, in 2021, an analysis of 69 prospective longitudinal studies of child spanking and its impact on subsequent behavior was published in the leading medical journal, The Lancet. Some have argued, in support of spanking, that there is a chicken and egg problem. We don't know if spanking causes bad child behavior or if bad child behavior elicits spanking from parents, and that's an important issue. The 2021 study was conducted to address this question head-on. They analyzed studies that followed children over time to see if spanking predicted changes in their behavior, taking into account, importantly, their initial levels of problematic behavior. These researchers found that spanking consistently predicts worsening child behavior problems over time, and that this relationship is robust across different child and parent characteristics. They conclude that spanking is harmful to children's development and well-being. Some have argued that the evidence against spanking is not strong enough because it can't definitely show that spanking is the cause of all these negative outcomes. It is true that experimental evidence, the bedrock of science, is difficult to obtain with regard to spanking because our ethics committees do not allow experiments in which children are randomly assigned to be hit. However, numerous researchers have used quasi-experimental statistical methods to get as close as possible to an experiment. Separate studies using these methods, with data collected from Colombia, Japan, and the US, have universally found that after they are statistically matched on family and individual demographic characteristics, children who are spanked have worse behavior and worse performance on cognitive tests than children who are not spanked. These studies provide strong evidence that spanking does lead to worse outcomes for children. Another argument that I have come across is that hugging children after spanking helps reduce any potential harm. Research has indeed indicated over and over again that showing children love and warmth is good for their development. However, such love and warmth is not enough to counteract the harms of spanking. And research has shown that spanking predicts increases in child aggression over time, regardless of how warm parents are to their children. Colleagues, there's no solid research evidence that mild physical punishment is effective in improving behavior or in any way consistently beneficial to children. There are, however, numerous studies showing that hitting children increases the risk that they will become aggressive and develop mental health problems. In short, spanking makes the parent's job harder, not easier. Also in my research, I came across some arguments that it is biblically directed to hit children as a form of correction. In my assessment as the son of a Presbyterian minister and longtime churchgoer, this is not the case. Is there any place in the Bible where the words of Jesus Christ encourage parents to hit their children? Nope. Indeed, quite the opposite. Jesus Christ recognized the responsibility of kind and considerate parenting, and that did not include hitting children. The King James Bible version of Luke 11 says, quote, "If a son shall ask bread of any of you that is a father, will he give him a stone? Or if he asks a fish, will he for a fish give him a serpent?" Or in Mark 10:15, quote, "Truly I tell you, anyone who will not receive the kingdom of God like a little child will never enter it." Or Matthew 19:14, let the little children come unto me, and do not hinder them, for the kingdom of heaven belongs to such as these. Does that sound like spanking to you? Are there passages in the Bible that have been interpreted as encouraging hitting children? Yes, there are. Mostly in the Old Testament, and particularly in the book of Proverbs. But before I address that, let me be clear. The book of Proverbs is not a child-rearing manual. The classic verse that is quoted, Proverbs 13:24, states, he that spareth his rod hateth his son, but he that loveth him chastiseth him betimes. End of quote. That is the basis for the saying that many people think is written in the Bible, quote, spare the rod and spoil the child, end quote. Well, that statement actually does not appear in the Bible. It was created by one Samuel Butler, a 17th century poet. It appears in a poem called Hudibras, where a love affair is likened to a child and spanking is mockingly commended as a way to make love grow stronger. The verse reads, quote, what medicine else can cure the fits of lovers when they lose their wits? Love is a boy by pet styled, and spare the rod and spoil the child. But if we unpack even that verse from Proverbs, does it really mean a parent must use a rod to beat a child? Not at all. On the contrary, the use of the rod in the Bible is not as an instrument of corporal punishment. The shepherd uses the rod to guide, to protect, and to count the sheep. Recall the image of the rod in Psalm 23. Yea, though I walk through the valley of the shadow of death, thou art with me. Thy rod and thy staff, they comfort me. To spare the rod doesn't mean to beat the child. On the contrary, it's the responsibility of the parent to guide, discipline, and protect. The rod is an instrument of guidance, discipline, and protection, not a tool to hit with. And chastise does not mean to hit. It means to correct or chasten. Numerous biblical commentators and Christian parenting organizations support this perspective. Some don't. The rod is a metaphor for guidance and discipline. It is not a directive to hit a child. Children can be disciplined without spanking. As Thomas Haller, a Christian parenting and relationship expert, notes, they can be treated with, quote, grace, integrity, and love, end quote. Part of the process of ending child-rearing approaches that encourage parents to hit their children should be the work of legislators such as ourselves. We can end the special protection given by Section 43 to people who hit children. We, and this is so important, can support the dissemination of best available evidence-based interventions that help parents and other adults use different, nonviolent, and effective forms of discipline and guidance. We have that knowledge now, much more knowledge than we had 5 years ago. We can right this wrong now. Senators, it's time to act on action number 6. We're coming up close to 10 years since the final TRC report was presented. Providing safe and secure environments in which children can grow and flourish is what we all want to have. These environments must include the home as well as all other places. We have many tools in our child guidance toolbox that we can use to improve the lives and outcomes of all the children in this great country of ours. Repealing Section 43 is an essential and very much needed tool for this toolbox. I ask all of you today to work together to quickly move this piece of legislation through our chamber to detailed study at committee, to help us live up to the commitments that we as a nation have made to protect the rights of our children and to advance the process of reconciliation that we are all committed to. It is important to see this bill through so that we can say, once again, the Senate of Canada has acted to help the children of our country grow up safely and flourish. I end today with the words of Marvin Bernstein, the child and youth advocate for Prince Edward Island. Quote, "We must all take a stand to state emphatically that physically striking children is wrong under any circumstance. It is a matter of ensuring protection for the fragile bodies and tender hearts of our most vulnerable citizens." End quote. Miigwech, Walalio. Thank you and mercy.